All right. Welcome, everybody. Without further ado, we'll go ahead and get started. So we're on week 3, which is sort of expanded a couple months just due to travel and the market updates that we've done and some other things that have spiked up. The ERC credits have been top of mind with a lot of my clients of late. So today we're going to talk about wills and trusts. Today's topic will be the Secure Act and your estate and estate plan. And then next week we'll wrap it up with the impact of a customized estate plan. Today, we're going to go over what is a fiduciary, beneficiary designations, the Secure Act, and then some estate planning comparisons, right? So the thing that I think is important here, because this word gets thrown away, and sometimes people are assigned a position and although good intentions, you're right. So let's take an example, right? I'm married, right? I turn around and me and my wife, we sit down and we do legacy lock, and we're looking at what is a successor trustee, which is an executor or a trustee, and we start plugging in people that we know, and we say, hey, or we've gone to an estate planning attorney, and we say, I want my brother or my sister or a family member to be the executor or the trustee. What a lot of people don't understand is that you've handed them a responsibility that they may not be aware of what it encompasses, and the responsibilities that are required, and the level of professionalism that is really needed. So although it's a difficult decision, right, sharing with each other, and ultimately how do we transfer our assets, our wealth onto somebody, who is that? And then that person, the advantages of using a professional fiduciary. I've been executors of estates, I've been trustees. I can tell you I don't want the job, right? And the reason is my RIA puts a kibosh on that. They don't want me doing that either, because I think it opens up liabilities. But the second thing is I did it for, you may have heard me talk about, one of my clients that owned a dental lab, and he had 2 children. And then he was remarried, and his second wife, Anne, had 5 children. And I can tell you, having watched that firsthand as the death of both of them happened, and how the clause came out. And I have an expression, and that is money makes people funny, right? So things that were intended, I knew Art and Ann really, really closely. And he told me, he says, look, I want you to make sure that when I pass, that Ann is taken care of, right? But ultimately, after she passes, I want that money to go to my children. This was his family business that he built, that he wanted to redirect back to his kids. And good thing we did estate planning, because her children, who in all the years that I had known him, I met one of them like 1 or 2 times. But as soon as he died, they popped up and were in mom's ear. And they started to try and pull some funny stuff. And I was able to circumvent some of it, but it came almost to litigation with the one son out of California. And so I share that with you because, as we're going through, and a lot of us, I can tell you that when I had my brick and mortar in Somerset and I'd be talking to folks, I'd say one of the first questions you'll see on our intake form is, do you have a will? Do you have a trust? And 9 times out of 10, the answer is no. But if they do have it, it's usually 10 years old, right? 15 years old, 20 years old. Very rarely do I see documents that are currently dated. And the rules have changed. And, people that you pick, because it is such a difficult conversation to have, and where we were at, 10, 15, 20 years ago is not where we're at today. Maybe some of the people that we wanted to name were more in place for guardianship, or as custodians, or sort of to make sure in the event of our children, as something happened, that they were okay. And, and then as, maybe they were minor children. But now those children have moved on, and things have changed, relationships have changed. So, there's a lot that goes into, these thoughts, which is why so many people are apprehensive about doing any type of planning. But when you're doing this and you start naming people to inherit this responsibility, you have to go into it with your eyes open. And I would encourage you to ask the people if they're okay being the executor in the event that you pass. Are they willing to accept that responsibility? Right? Because again, there are advantages to when you know people personally, right? And that's the familiarity. They know the people in the family and how things should be divided. And typically they're going to be more reasonable with costs. So I spent a little bit of time on that because it is a word that's thrown around, but anybody that steps into that role has a legal responsibility to act in the best interest of the person that has named them. So just be aware. So beneficiary designation, there's terminology. And again, I'm not an attorney. This is legalese, right? Old Latin, per capita, per stirpes. Just think of per capita as per head. And so what that means is when we're naming beneficiaries and we're naming our trusts and our documents, if we turn around and we want it per capita, so let's say in the example, by total head count or by total number of individuals in a per capita inheritance, should both parents and one beneficiary child die, the IRA would be divided equally among the remaining benefit children. So it would just sort of flow to the other children, right? Without a whole lot of resistance. But per stirpes works a little differently. So, if those, in this example, the one child that ended up passing had children or grandchildren, that were also involved, it will continue that in that branch. So by representation or by class in a per stirpes inheritance, should both parents and one beneficiary child die, the percentage of the IRA that would have gone to the deceased child now will continue on down through that lineage. And sometimes that can be a good thing. Sometimes that can be not what the parents or the people that are the grantors wanted. And you have to think about this because, again, money makes people funny. We can't plan for every possible scenario, but we can do a pretty good job. Were they married? Were they remarried? And let's say it was, we wanted to go to our grandchild, but they married somebody and we don't like the son-in-law. And next thing you know, they're getting all the money and they are now the custodian for the grandchild. It can create a very complex picture unexpectedly. And so this is why it's such a difficult topic. This is why it's so hard because we can't plan for every scenario and things change. Right? Relationships, we have children, they get married, and then, unfortunately, sometimes divorces happen or deaths happen, or, relationships sour. And so then what do? Do you go back and go through all your documents again? And so it just thought should be given, but it should be revisited every 5, at a bare minimum, every 10 years, because there's also the tax component. But let's talk about this now, the Secure Act. The Secure Act went into effect in 2019. And then it was written in 2019, went into effect in 2020. And the way that it worked was it used to be, and I'm just going to arbitrarily use some number. Let's say that a husband and wife, and the husband in this example had amassed $2 million in some type of IRA or 401k. Under the way that things used to be and the planning strategies of old were that ultimately that would go to the spouse upon the death of the one. And then actually once that spouse passed, it could go to the child, the daughter, the son, and they could use their life expectancy. It's called the stretch IRA. Well, that was written out of law back in 2019, effective 2020. So now we have to be cognizant of the changes of the rules, because maybe now the beneficiaries of that $2 million, maybe it's better to give only $1 million to the spouse and $1 million to let's say in this example, the daughter, because what's now required is that a spend down of whatever the IRA that was received inherited must be spent within 10 years. So the Secure Act, what that stands for, setting every community up for Retirement Enhancement Act of 2019, the Secure Act. Tax planning with a split beneficiary method. A shorter time period to fully distribute a taxable account, 10 years, could push some of the beneficiaries' distributions into a higher tax bracket. Think about it. If you were turning around and that whole $2 million went to that daughter, right, and they got to spend it down in 10 years, that you could be handing them, if it was $1 million, it's a $100,000 for 10 years, or $2 million, $200,000 for 10 years, plus whatever income they're earning. It bumps them into a higher tax bracket. So to counter, individuals would need to focus on more tax efficient planning as part of their retirement and estate planning process. This also means paying attention to which beneficiary is receiving the IRA. Leaving all of an IRA to a high income child could be a bad way to maximize an account's tax benefits. Additionally, leaving all the account to the surviving spouse at the death of the first spouse might no longer make sense. That was the stretch IRA I was talking about. It might be better in some cases to now leave some of the IRA money for tax planning purposes at the death of the first spouse. For example, let's say the husband passes away, they leave $1 million to. In the past, best practice was just pass it over to the surviving spouse, who might want to combine it to her own $1 million IRA. Then she passed, and the daughter, they could spread the $2 million over many years, right? So, however, under the Secure Act, the daughter would now need to distribute that over 10 years, and that would be $200,000, like I was just mentioning. It might have been better to split up the dad's IRA, sending maybe half to the surviving spouse and the other half to the daughter. This would have allowed the daughter to start a 10-year RMD on the father's $500,000, $50,000 a year, while leaving the other half to mom. Once mom passed away, that left the remaining $1.5 million. If in 10 years had passed, the daughter would now have another 10 years to distribute the $1.5 million or $150,000 a year. In essence, what they're trying to do is that with as much possibility, we're trying to mitigate some of the tax risk that's now on the table when the Secure Act took stretch IRAs off the table. Now, another technique that used to be in vogue and then sort of went away, but it really is something to be considered now, is something called a charitable remainder trust. Now, there's different types of them. You'll have CRUTs and CRATs. I'm not going to get into too much technical detail right now, but basically, charitable remainder trusts also provide a potential benefit under the new rules. CRTs can be named as a beneficiary. So in the example, what that means is if mom, dad didn't need the IRA, they could actually put that money into an irrevocable trust or a charitable remainder trust. Depending on how the asset went in, depending on the type of asset that was there, this is where it can get a little complex, and you should talk to a financial planner or an estate planning attorney. If it's a highly appreciated asset, there's some benefit to doing so. If it's cash, it can be a tax deduction now in the year, but all that, gets a little complex. But the goal is, and really the way that it works is if you put in $1 million, it's a way really for a non-spousal beneficiary, so like a child, to be able to sort of take 5% off of that trust. So $1 million went into that trust, 5% or 50 grand could come out. That $1 million can continue to grow or fluctuate, whatever. And it's based on 5% of the value. So maybe every year is not 50 grand, but roughly, let's just keep the math simple and say we get 5% every year. 5% is 50 grand. That gets distributed out to the beneficiary for their lifetime, right? And that's a way to preserve it. And then whatever's left over will go to a charity of the grantor's design. So it's a technique, it's a strategy, it's plausible. It will allow for folks that maybe don't need that money to be able to take advantage of some of the nuances of the Secure Act and the current legislation. So for instance, you could have payments from the CRT to a child as a beneficiary for 20 years. At the death of the child or the end of the term, the benefit trust would pay or pass to the charity. In general, the owner would still need to be charitably inclined, but with a 10-year mandatory distribution of an IRA, a CRT could be an overall tax benefit. So it's just a strategy. It's not for everybody, but they are starting to at least be a little bit more palatable now. We've been talking about Sean and Mary and their assets, and the only thing on here that just be aware of before, right, where we can name beneficiaries and it goes to it. Just keep in mind that if we name IRAs, the way that the law works now is that money now must pass within 10 years. As we see here, that he have 250 or 150,000, and when they name a child, that's the other thing is, New Jersey has an inheritance tax. Now, depending on the classification of beneficiary that you are, there's type A, which means if you're a spouse or a child or a grandchild or even a stepchild, you're granted no inheritance tax. However, if you're a brother, a sibling, cousin, nephew, niece, anything like that, you start at 11% up to 16% of taxation on the values of the money inherited, right? So there's a lot of taxes out there that are coming from all sides, right? So this is, again, why it's important to do some estate planning, start to make sure that what you want to have happen, and we always talk about building your circle of wealth and preserving it and helping you to keep it, so that as you start to transfer these assets to your loved ones, right? We want them available for us while we're alive, but two things that are certain in life are death and taxes. So we have to take steps to preserve what we got, make sure that we have access to it while we need it. But as we get pretty comfortable, we start to look out into the future and go, you know what, we can't take it with us, right? So how do we make sure that the government doesn't get a majority of, and there's different forms of government, right? We have the state government and we have the federal government, right? And that's what we're dealing with. And then we have inheritance taxes, right? Which is there's only 6 states that charge it. So depending on where you pass, right? It's crazy to think about that, but you decided you want to stay in New Jersey because you were closer to your children and grandchildren. And then, next thing you know, New Jersey's got their hands in your pocket again, right? So it's just, there's a lot of things that we have to take into consideration as we're doing our planning. Lastly, this is just whether we have no plan, a will plan, or a trust plan. So, joint assets pass to Jane, joint assets pass to Jane. If properly funded, Jane's assets, even joint, will remain in the trust. So, there's benefits. The trust, there's a lot of different types of trust, right? It's ad nauseum. Everybody's circumstances are different. Nobody can do planning for free. I don't begrudge anybody for making a living, charging a fee, whatever they do to provide professional advice. However, we need to know that if you leave things to chance and we leave it to New Jersey, we're probably going to be on the higher side of fees. And when you start to think about it, 5 to 8% on $1 million could be, 50 to 80 grand. That's not going to your beneficiaries because we didn't do any planning. So keep that in mind. Next week, we're going to talk about the last part, wills and trust series, the impact of a customized estate plan. I hope this, is beneficial to everybody. I hope everybody's well. If you need me, call me, email me. Happy to help. Again, I'm not an attorney. I'm just sharing my experiences with you. This is a topic where I find most people have a challenge with it because they end up, they almost go, I use it from a book, Watership Down, Thorn, right? They heard the train coming, so they froze on the track, right? They don't know what to do. And it's because it's so intimidating, so complex. You don't want to make a mistake, or you're just like, I don't have anybody. I don't know who to pick. I get it. So, sometimes just talking it through. And I just know that the last thing I want is New Jersey getting anything that, that they're not entitled to, right? So I'm going to figure out somebody, a niece or a nephew that's going to be, I'll be that great uncle that is going to share it towards them versus giving it to New Jersey in their coffers. Guys, I hope all of you are doing well. If you need me, call me. Have a great day. Bye-bye.